Hi, this video is a follow-up on one I posted a few days ago about bank accounts triggering probate. In that video, I listed two options for solving that problem. One was to use the Payable-on-Death feature to designate specific beneficiaries in your bank account. And if something happens to you, the asset goes straight to the beneficiaries. The second method was to retitle the account to the revocable living trust. After I posted the video, I received comments and a few viewers asked me, hey, what about if we put the living trust as one of the designated beneficiaries in the account? And another viewer asked me about the option of adding my child as a co-owner of the bank account. I do see the appeal of those two additional options. They're easy to set up, and also they do not change the character of the bank account. It stays nimble as a regular account for day-to-day banking. However, there are downsides. If your only goal is to avoid probate at death, that works. And to be fair, the caption of that video was how to avoid probate. So I really should have brought up this option as a viable option to avoid probate. However, estate planning is more than just about what happens at death. It's also about planning for incapacity. Bear in mind that if I'm incapacitated, designated beneficiaries doesn't kick in. That's why the feature for bank accounts, it's called Payable-on-Death. So if I'm incapacitated, that account cannot give access to the beneficiaries. The only person at that time who can access the bank account is the power of attorney. Hopefully, I have picked a financial power of attorney to manage my financials on my behalf if I'm incapacitated. But if I've not, then the account will be frozen until the court assigns a power of attorney for me. On the other hand, if you have an account that's owned by a trust, then if something happens to me, if I'm incapacitated, simple. The successor trustee steps in and takes over the management of the account. There is no disruption, no extra paperwork to be filled out, no change in status requests on the account. The successor trustee is part of the system of the trust, so he simply steps in to manage the account. And I don't know about your bank specifically, but most banks much prefer to deal with successor trustees than with power of attorneys. Now let's talk about the other option that was brought up, making my child a co-owner of the bank account. If something happens to me, whether I'm incapacitated or whether I die, my child continues to own and manage the account. That really sounds great, and there are a lot of pluses in terms of conveniences, especially if I'm elderly and I need my child to be paying my bills, to be processing my deposits and things like that. There are definitely pluses in that. But just understand that when you make your child a co-owner of your bank account, he legally has full rights to your account. He can legally withdraw money, write checks, take a loan out against the bank account, even if it's against your wishes. That's the first problem. The second problem is that if your child, God forbid, is involved in a bankruptcy, a lawsuit, a divorce, then this asset becomes vulnerable because legally it's considered to be his asset. Another disadvantage I can think of is if I die, this account becomes legally and completely his. I may have instructions in the will that the money should be distributed to his siblings or his mother, etc., etc. However, legally, he has full ownership and control of this bank account. Is that what I want? My definition of a good strategy is full control while I'm alive and bypass probate when I die. When I add someone as a co-owner of my assets, I have relinquished that full control. I see parents, especially Asian parents, I don't know why, adding children as co-owners of their homes. They think, oh, I'm going to save spending money on creating a trust. Why do I need a trust? If I die, my child will get the house. That's my intention anyway. Just bear in mind that while you are alive, this child also has full legal rights to your house. He could mortgage it, he could take a home equity loan against it, and once again, if he is in a lawsuit or bankruptcy or divorce, the house becomes vulnerable. There is another even bigger reason to not do this when it comes to your house. The step up in cost basis allows you to wipe out capital gains tax when you die and your house passes on to your child. He could sell the house the next day and pay zero capital gains tax. Well, you have stripped yourself of the ability to do that when you make your child a co-owner of the house while you're still alive. If you missed my video on how the step up in cost basis could potentially save you hundreds of thousands of dollars on capital gains, you can find the link on this page.